Hi, I'm Dave Miranda, General Counsel and past President of the New York State Bar Association. Welcome to Miranda Warnings. You have the right to remain listening.
Right, this week on Miranda Warnings, we have Kathleen Marie Sweet, the 128th President of the New York State Bar Association. Welcome, Kathleen.
Thanks for having me.
It's great to have you. Kathleen is also a partner at Gibson, McCaskill, and Crosby in Buffalo.
True.
Lifelong Buffalo Bills fan.
Season ticket holder.
And now the highest honor, guest on Miranda Warnings.
That's true.
How are you enjoying your time as president?
Oh, very much. I'm learning a lot and getting to meet a lot of great people.
And as you know, the president of the New York State Bar Association is our main spokesperson and advocate for our policies. And there's certainly a lot to talk about. Currently, our institutions of government, our justice system, our court system are under attack federally. And you recently wrote an op-ed in Bloomberg News about how U.S. attorneys have been selected under the current administration. Why is it that that issue was you thought was so important that you needed to speak out on it?
Well, among other reasons, I think it goes to the need for expertise and experience and competence in those positions. Those lawyers are entrusted with enormous power and discretion. And so I think it's extremely important that they have experience, good judgment, and are well vetted and confirmed by the Senate.
So we're talking about the selection of U.S. attorneys at the various departments around the state that prosecute federal crimes. And for those unfamiliar, maybe you could explain like the normal constitutional process for selecting and confirming U.S. attorneys under normal circumstances.
Well, traditionally, the president can appoint, but that appointment is subject to a vetting process and Senate confirmation. And what goes into the vetting process is a rigorous investigation of the person's experience, competence, temperament, judgment, including interviews with other lawyers in the legal community where they practice to make sure that that is a person who should be entrusted with that kind of power.
And why is it important that we have a vetting process for individuals that are leading the various U.S. attorney offices around the country on behalf of the Justice Department?
Well, because just because someone holds themselves out as competent or is appointed as competent by one political party or another doesn't necessarily mean that they're well suited for that kind of position.
Now, you have some personal familiarity with the federal confirmation process, right? Well, you were nominated by President Obama to serve as a U.S. District Court judge in the Northern District, so you went through that process.
In the Western District, yes.
In the Western District of New York. And tell us a little bit about that experience and the process that you went through, which is, I don't think identical to the U.S. attorney, but similar.
Yeah, no, it's a little different, and it's a little more involved because that is a lifetime appointment, should you be confirmed by the Senate. But it's a very rigorous investigation that goes on. It starts with the completion of a very lengthy, over 50-page questionnaire that goes to, in my case, the screening committee designated by Senator Schumer, the senior senator for New York. And from the questionnaires, the committee chooses a handful of folks to interview. So I went to an interview with the Senator Schumer's screening committee, and after that interview, I was then interviewed by Senator Schumer himself. And while that was going on, there was also a concomitant investigative process undertaken by the committee with regard to my credentials, experience, competence, temperament. And by that, I mean they had cases with lawyers that I've been opposite side of cases from, judges I've appeared before. And then once Senator Schumer decided to recommend me to the president, that opened yet another series of investigations that included an FBI investigation, another round of questionnaires and submissions that I completed. In addition to the FBI investigation, the White House counsel investigated me and interviewed me. FBI agents spent a day at my law firm talking to everybody at the firm about whether I was competent, capable, had the necessary temperament to preside as a lifetime appointed federal judge. And then, of course, then you go through the Senate confirmation process. I managed to proceed through the nomination process to the point where I had a hearing, was questioned by a Senate confirmation panel, and then was, I'm humbled to say, unanimously voted through by the Judiciary Committee. But at the same time that I was going through that process, Merrick Garland had been nominated for the Supreme Court.
So this is 2016.
2016, and the Senate Majority Leader at the time was Mitch McConnell, and he put a hold on any Senate votes for Obama judicial nominees. And so my nomination, like many other dozens of others across the country, died up for the Senate. Oh, there was one other thing, actually. I also had to go through an investigation by the American Bar Association's standing committee on the judiciary, and that was a 4 or 5 hour interview by one of the senior members of their committee. So there was no poor unexplored
Right.
in the connection with making sure that they felt I could handle the job and, participate in the dispensation of justice in our district.
Right, which of course is grueling for a potential nominee, but provides some comfort to those that have to appear before the courts to know that they've been fully vetted. And I think the issue in your op-ed was that we do have a similar process for selecting U.S. attorneys, and that process is now being
Sidestepped.
Because they're not going through the Senate confirmation process. They're just getting appointed as an interim U.S. attorney, for example, in a couple of jurisdictions. And then with that interim, which can only be for 120 days, that interim goes out, expires, they're getting appointed, they're just remaining in the position.
Yeah, it's been I wasn't aware that was even a thing, that you could, once the judges of the district, after the 120 days expires, the judges of the district can essentially vote and decide to retain that person for a period of time. But even in situations recently where the judges in their respective districts have decided not to approve those acting U.S. attorneys for extension, the Department of Justice has ascribed a special attorney status and has either moved up a deputy and then discharged or fired the deputy and then reassigned the attorney whose 120-day acting U.S. attorney time frame is expired, and you don't get sequential 120 days. So they've assigned them this new, well, maybe it's not new, but this previously undescribed or unenacted term of a special U.S. attorney.
Right. So now we have people in the U.S. attorney position who have not gone through the vetting and confirmation process that you described, have not gone through the kind of backup. If you can't get someone confirmed, you just get them approved by the district court judges who, presumably will act in a balanced way and oftentimes put in someone who's a career prosecutor in the area so that the district can function. So we don't have that.
And so that the office of U.S. attorney can function.
Right.
I mean, in 93 districts, there are dozens of lawyers who are carrying out the functions of the U.S. Attorney's Office, both criminally and civilly. And so those lawyers, are entitled to have a leader to make the most important decisions in their office.
And now, not in every district, some districts have gone through the proper process, but in a handful of districts, for example, in New York, Northern District of New York, and New Jersey, Eastern District of Virginia, we have not gone through that process. And so what's the impact on our Department of Justice and our prosecuting as a result of the fact that we have people that are leading prosecutions that have not gone through this process?
Well, I think it's unfortunate because I think it further dilutes and undermines public confidence in the decision-making and charging decisions that are made by those officers of the court, those acting or special U.S. attorneys.
Right. And we've seen, at least, for example, in the Eastern District of Virginia, where there was pressure to indict former FBI Director James Comey and New York State Attorney General Tish James, the prior U.S. Attorney found that there was no basis for bringing forward an indictment against them, but then that person was fired, and then someone else was put in through this unconfirmed process and actually acted on it. And
that U.S. attorney had been installed by the current Justice Department. It wasn't a holdover from the Biden Justice Department. And to his credit, made a decision and recommendation to the Attorney General that there was insufficient evidence on which to charge and support a conviction of the former FBI director. So to the extent that political affiliates of the president or the Attorney General are now in those important positions where charging decisions are being made, I think it further adds to the notion that the Justice Department and government in general has been weaponized against, quote unquote, the other side.
And you talked a little bit in your article about how, in our Constitution, those that drafted the Constitution kind of anticipated this being a potential issue, and so they had the checks and balances that, the president gets to nominate someone, the Senate gets to confirm them, so this way there will be a check. And now we've lost those checks and balances, and we have individuals now that are U.S. attorneys that haven't served as career prosecutors, as normally the case, haven't served, in a apolitical way, which is normally the case. And so when we have that, what kind of issues are we seeing now in our justice system as a result of that?
Well, I think this is just one example of how dangerous it is for Congress to cede its authority and responsibilities to the executive branch. And I think what the founders, what the drafters intended was for there to be tension between or among the three branches, not for there to be acquiescence by Congress to the goals or aims of the executive. And as we all know as lawyers, the third branch, perhaps the branch of last resort, moves more slowly. And so the check on Congress and the check on the executive that rests with the judiciary is often left to play catch up. And that is just another example of how the checks and balances have been weakened.
Now, there's often a question that's brought to us at the Bar Association. Well, what can the Bar Association do, right? And what can its members do? Do you have any thoughts on the type of things that we can do to, address these issues that obviously the courts and the justice system is of import to the Bar Association and attorneys?
Of course, absolutely. And that's why that was one of the issues that I thought required me to speak out, because it does directly affect the administration of justice, lawyers in particular, and the communities where those U.S. attorneys are serving. And so that was an area where I thought it was most important to speak on behalf not only of lawyers, but on behalf of the system, and to speak up for the Constitution. That doesn't mean that we can, as a bar association, swing at every pitch. There is a lot coming out of the White House, the administration, the agencies, the dismantling of our institutions, and there are ways in which individuals can mobilize against those things. First and foremost, they can vote, and they can talk to their friends, their family, their coworkers, people that they meet with in other community organizations. The Bar Association will certainly speak out when courts, lawyers, the rule of law, the administration of justice, the independence of the judiciary, then those things are front and center. We will do our part, but as much as I like to say it'll take all of us, it will take each of us to do our part to preserve and continue our democracy.
Well, of course, this is a very important issue, and I know many in the association appreciate the fact that you, spoke out on helping, I think, both attorneys and the general populace understand the importance of this issue. But of course, as president, the Bar Association is doing a lot of other good work. I know you're fortunate enough to be president during the year of our upcoming year of our 150th anniversary. We have our annual meeting coming up in January with our gala that I know you're very excited about. I don't know if you want to talk a little bit about what's happening at our annual meeting and with our gala.
Yes, so the annual meeting is going to kick off the celebration of our 150th anniversary year. The gala will be sold out, so I hope that folks are getting their tickets or sponsoring their tables. And as far as the presidential summit is concerned, I think it's appropriate that this year we focus on the Constitution and its fragility under the current circumstances. And we have a Pulitzer Prize-winning historian from Stanford, Jack Brakoff, and the Rule of Law Clinic at Yale's director, Sonia Mittal, who are going to address that in a conversation moderated by Lawrence O'Donnell. So I'm really looking forward to that. And I'm sure there will be hundreds of lawyers that'll participate and attend and hopefully get some advice on what they can do to address these issues that we're all talking about.
Well, sounds great. The annual meeting and the gala is going to be in January of 2026. The gala is actually January 15th at the Plaza Hotel for anybody that's interested in attending. So Kathleen, thank you very much for being with us here on Miranda Warnings and for your service not only to the Bar Association, but to our profession. Thank you.
Well, thank you. I appreciate it. And it was a nice opportunity to be with you.
This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.